You've just suffered a fall. It could have been indoors, outdoors, weather-related, non-weather-related. It could have been on a city sidewalk. It could have been at a residential home, a commercial property. My name is Dallin Fuchs. I'm a personal injury trial lawyer practicing civil litigation in the state of New York. And I want to share with you today some great information regarding how these types of cases work and how your case would work in terms of consulting with a lawyer and going forward through the process. In any type of accident such as this, you're going to need to prove a lack of reasonable care on the part of whoever might be responsible for your accident. It could be a homeowner, a tenant, it could be the city, it could be a landowner next to a city sidewalk, but we need to prove negligence, which really is just a lack of reasonable care. How do we prove negligence or a failure to use reasonable care in accidents of this type? Well, basically, there are three major ways. One is the responsible party or the defendant a party that actually created the condition that caused your fall? That's one very common way to prove fault or liability for your accident. A second way is to prove that, well, although the defendant, the person you're suing, didn't actually cause the condition, they knew about the condition. We could find this out through investigation from employees, former employees, maybe videotape that exists from the store. So that's a second way to prove negligence or lack of reasonable care, showing that they actually knew that this defective or dangerous condition exists. And the third, very basic common way that you would prove negligence or a lack of reasonable care in cases like this is to prove that the condition, whatever it might be, was there for some type of prolonged or extended period of time. And again, we can prove this through investigating your case. Perhaps the substance that caused you to fall, for example, in a supermarket, was there for 45 minutes or an hour. It could be proven through a witness, through a videotape, and through that we prove a lack of reasonable care. All of these types of proof involve proving that the defendant knew about the condition or should have known about the condition and therefore should have done something about it in the exercise of reasonable care to cure it. So why am I sharing this information with you? Because you've likely just been involved in a similar situation and you need advice, and I'm here to answer your questions. Call me. I'm here. This is what we do all the time, and I'm here and happy to answer your questions. Again, my name is Dallin Fuchs. I'm a trial lawyer practicing civil litigation in the state of New York, and thank you for watching.